Hello friends, in the series on the income tax cases, today we will discuss a case in which an issue was before the Honorable Gujarat High Court through an income tax appeal by the department that if the assessee purchases the shares of a company and at the time of purchase of the shares of a company, that company's trading was suspended on the stock exchange and the assessee earns some profit which is exempt under section 10 subsection 38. So whether on this sole ground that the assessee has purchased the shares of a company at the time when the trading of those shares was suspended on the stock exchange, the addition can be made only on this ground. This issue has been taken up by the court in the case of Principal Commissioner of Income Tax versus Ambalal, Chimanlal, Patel. This case is reported in 478 ITR at page number 514 and the date of the judgment is 15th April 2024. The assessment year is 15-16. During the year relevant to the assessment year 15-16, the assessee has claimed long-term capital gain exempt under section 10 subsection 38 on the sale of shares of an entity N. The assessee was holding the shares of other 15 companies also. Since the assessee has earned the substantial amount of capital gain from the shares of a company N and the assessee has purchased the shares of that company N when that company trading was suspended on the stock exchange. So when the assessment proceedings were going on, the learned assessing officer was of the view, and that view was based totally on the basis of suspicion, that the purchase and sale of shares of N by the assessee was a carefully executed plan to generate the bogus long-term capital gain, and the shares of company N were purchased at the time when the trading was suspended on the stock exchange. But when the assessee filed the appeal before the CIT appeal, the CIT appeal observed that the assessee was holding those shares for more than 3 years and the assessee was holding the shares of some other companies also. So solely on that basis, that at the time of the purchase of shares, that company was not actively working on the stock exchange, the shares of the assessee cannot be termed as penny stock. So the CIT appeal deleted the addition. The same view was taken by the tribunal also. So when the revenue filed the appeal before the Honorable High Court, the court was of the view that all the lower authorities, all the lower appellate authorities, that is CIT appeal and tribunal, has mentioned in their orders that the contract notes were placed on record regarding the purchase and sale of the shares, and the court also affirmed the situation that the assessee was holding the shares of some other companies also, and the addition for the penny stock or for the sale of shares cannot be made just on the basis of suspicion. And the High Court was also of the view that it does not matter that the substantial amount of capital gain is coming from the sale of only one company, that is N. So the High Court was of the view that merely because the trading of that company was suspended at the time of purchase of shares by the assessee, the capital gain cannot be termed as bogus. The High Court was also of the view that in the absence of any material brought on record by the assessing officer, the additions cannot be made on the basis of suspicion. The AO was not justified in his finding that there had collusion or connivance between the assessee and the broker on the basis of just conjecture and surmises. So the additions were deleted by the High Court on the ground that merely because the trading of some share is suspended on the stock exchange, that scrip cannot be termed as penny stock. At the end of this video, once again I am repeating the name of the company, the name of the case. The name of the case is Principal Commissioner of Income Tax versus Ambalal, Chimanlal, Patel. and this case is reported in 478 ITR at page number 514, and the date of the judgment is 15th April 2024. Thank you, friends.